Right. Let me just take this comment and then we'll move to the next issue. Uche Sopolo says Fubara only has 3 members and not even being backed by the center. Too much for him. And then he's saying that Fatusi Razak said, I know that rancor would surely occur between the duo, but my problem is that it's too early into his administration. Anyway, we just have to move on to the next issue because we're already 22 minutes gone into the program. The certified true copy of the judgment on the Kano governorship election dispute contained contradictory resolutions, with the judge ruling in favor of and against the governor in the document. But the counsel to Governor Abba Yusuf, Wale Olanikwekun, said the Court of Appeal does not have the jurisdiction to correct the errors. What's your reading of these contradictions emanating from the court?
First and foremost, I respect Wale Olanikwekun, senior advocate of Nigeria, because he's someone who knows his onions and he's someone who has shown that he understands the game very well. And I doubt if you can point at 3 lawyers in this country without Olanikwekun being amongst the best 3 lawyers. No, especially when it comes to electoral litigation, he is a very successful advocate. When that controversy broke in the course of the week, I told people, look, the judgment was against Abba Kabir Yusuf. I told people that what happened was a clerical error, and it wasn't the first time that it will happen. It wasn't the first time, because I did my research, I spoke to lawyers, I spoke to judges, and they told me that this sort of thing had happened before. But looking at what we face in this country at this time with the judiciary in the eye of the storm, I'm not surprised that people are refusing to buy the idea that this was a clerical error. I've seen people like Professor Odinkalu say a lot of things about this, using the opportunity of this error to pillory the judiciary, to give the judiciary names. The shame of this whole saga is that you know how subjective Nigerians are when something goes against their beliefs, when a judgment goes against their favored party. This thing was clearly a clerical error, because in the open court, given the way the judgment was read and like the way it was going from the beginning, you could see clearly that the appeal court had made a decision in favor of the respondent, in this case the APC, because the first judgment was in their favor. When I was discussing with a friend of mine who is a lawyer, I said, okay, if Abba Yusuf's people are claiming that the judgment was in their favor, okay, let them not appeal now. Let them not appeal. Let us see what will happen. But Olanikwekun is wise, and he has already made up his mind to appeal. All that Olanikwekun is saying is that, look, let's follow the law. What the law says is that as at November 18, the appeal court had no power to make any decision on that matter again. And to that extent, they cannot alter, they cannot correct any clerical error in that CTC. They can't take any decision that relates to that matter anymore, because the time ceiling had already been exceeded. You can't call the parties and advise them to come up with an application for you to rectify the errors made in the certified true copy of the judgment. on November 23rd, when the deadline was November 18th. So it's a very straightforward thing that Olanikwekun is saying, that the law does not permit you to take any decision at all on that matter after November 18th. So that is the point. And he's saying, look, I have just 7 more days within which to appeal. So he had made up his mind to appeal. And he's saying only the Supreme Court can correct can make an order on the error made in the clerical, on the clerical error made in the certified true copy. I do not exactly blame those who felt that what is going on, because in the CTC released to the lawyers, the majority judgment delivered by Justice Moore Abraham Adumen in one breath gave judgment in favor of the appellant and in another favor the APC. In open court, or what he said in open court really matters, because the CTC is really a summary of what was said in open court. So in open court, Adumen said the appeal lacks merit and is hereby dismissed. But the CTC read in part that the judgment of the tribunal is set aside. So it is the CTC that's where we have this problem. Some have even said that it looked like sabotage on the part of some people in the judiciary who are used to work on the judgment and all that. Well, I believe that judges, no matter how lengthy their judgment is, must be able to read and read thoroughly to ensure this kind of error did not happen. You can imagine if this kind of error was made in the Presidential Election Petitions Court judgment, maybe Nigeria would be ablaze today. Some people will have latched upon it to say all kinds of things. But the point that I want to make is the Court of Appeal ruled in favor of the APC, but the CTC in one page appeared to contradict the judgment given in open court. Where you are faced with this kind of situation, it is not difficult to know the decision of the judges. And the decision of the judges is the decision made in open court on that day. So it's only a lawyer who wants to put his client's case in jeopardy that will be deceiving himself that, oh, the judgment is in our favor, therefore, you don't have to appeal. If you fail to do that, then you are joking with the matter in your hands. But Olanikwekun knows what he's doing. In spite of that, he's gone to appeal. So, and the governor of Kano is confident that at the Supreme Court that he will win. They believe that the grounds upon which the lower tribunal and the appeals tribunal gave the judgment were not valid. For example, the matter of stamped ballots. Who really is to blame? Ken Falana believes that it is the INEC that is to blame, because you can't blame the agents of the political parties. How can we have a situation in which more than 160,000 ballots were not stamped? They ought to be stamped. If people voted, their ballots must be stamped. That's more than 160,000 polling units. That's more than that's a result from thousands of polling units. You know, thousands of polling units. You tell me that their results were not stamped. It is wrong. It is wrong, really. So, because in many polling units, there are usually about at least 500 people per polling unit. So Look at 160,000. That's talking about thousands of polling units. Ballots on thousands of polling units not stamped. It really makes no sense. People believe that INEC, it was the governor should not be punished for the incompetence and lax attitude of INEC staff. But again, the court will say that any issue brought before, any document before it that is not stamped is seen as a useless document. But I think that the Supreme Court will look critically at that matter and take a decision that will be in the best interest of the people of Kano State and the judiciary in our country. The mistake has been made. I think that going forward, the judiciary has to be more careful because people will latch upon these mistakes and try to paint the picture of corruption and all that. But it's not the first time. There was a particular case of clear cut and paste that put a matter in Taraba State in the first paragraph or so of a matter outside of that jurisdiction. So perhaps because judges are overworked on election-related litigation, we are seeing some of these things. But thoroughness has to be the watchword to ensure that this kind of error does not happen. How can the judges decide, for example, that the NNPP lost the case,
That's right,
only for the contrary to be reflected in one page of the certified true copy of their judgment? And before the CTCs are released, they have to look at them thoroughly. But right. I know also that because these people need to file their appeal quickly, they will want to get the CTC out as quickly as possible. But even in doing that, you have to be sure that you've thoroughly checked and proofread the CTC before releasing it. It's a crying shame, really, that this happened in Kano.